Good afternoon, everyone. Welcome to the webinar Under the Radar, Prosecuting Intimate Partner Sexual Violence. My name is Emily Thrush, and I'm the Senior Project Coordinator at Equitas. And today's webinar is made possible through funding from the U.S. Department of Justice Office on Violence Against Women. And Equitas is marking the end of the month of April, which is Sexual Assault Awareness Month. The majority of sexual violence victims know that they're assailants, and that's a fact that can greatly affect and complicate the reactions that victims experience during and after an assault. And sexual violence perpetrated by intimate partner presents further complexities in that victims may have complex feelings for the offender and may seek a continued relationship with the offender due to those feelings. So this presentation will describe the common dynamics, prevalence, perpetrators and victims of intimate partner sexual assault, and it will examine ways in which allied professionals may need to expand their practices to adequately and holistically care for those victims. And it will summarize the legal issues relevant to the prosecution of intimate partner sexual violence. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking and human trafficking cases, by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. And our staff is comprised of former prosecutors with over 100 years of collective experience, and they conduct legal research, provide 24/7 case consultation, and serve as mentors and instructors from around the country. And they publish resources. Today's presenter, we have two presenters actually, Jonathan Kurland, who's a colleague here at Equitas, and Tom McDevitt, a retired lieutenant after 35 years at the Philly Police Department. And Tom has extensive patrol, undercover, and investigative experience, including over 17 years of supervising sexual assault investigations. He has trained allied professionals on subjects related to police science, homicide, and sexual assault investigations, crime scene analysis, interviews and interrogations, forensic evidence recovery and DNA significance, child pornography investigations, and child abuse investigations. And John Kurland is an Equitas attorney advisor, and he provides training, case consultation, and resources for prosecutors and allied professionals handling cases involving violence against women. And prior to joining Equitas, John worked for 16 years as a prosecutor in the district attorney's office in Berks County, Pennsylvania, where he was serving as the chief deputy district attorney, chief of trials, and assistant district attorney. And throughout his career, he's also successfully prosecuted domestic violence, homicides, campus sexual assaults, cold case sexual assaults, intimate partner violence, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. So both of the biographies for these presenters is available in our download box here on the screen, and we will be sending this out afterwards as well. So just as Patricia described, feel free to use the chat box throughout the webinar if you have any questions, and if we can get to them, we will. Otherwise, we will circle back with you after. And like she said, we are recording this, so we'll be sending that link as well, probably early next week. So now I'd like to turn it over to John for this and Tom for the substantive portion of today's presentation. Thanks.
Emily, thank you so much for that introduction. And Patricia, thank you for your assistance in administering this webinar and making these resources available. And thank you everyone for participating. We have a large audience today, and the interest in this subject is exciting and promising. Tom, if you're ready, I'm going to start getting right into the content, if you're okay with that.
I'm ready. I want to thank everybody for being here, and it's a great day for this course after the conviction yesterday in Pennsylvania.
To start with, I want to make an acknowledgement to the pioneering work done by Teresa Scalzo, and a lot of the information, a lot of the content, and a lot of our understanding of best practices was informed by the work she did. And so, of course, the material we're going to present, it wouldn't be right without offering an acknowledgement to the contribution she's made to this field. So let me talk overall about the objectives we have for this presentation today. One, what we want to do is we want to be able to identify and respond to victims of intimate partner sexual assault. And at this point, I just want to sort of address terminology, pronoun usage, and things like that we're going to be using. Generally speaking, throughout this presentation, I'm going to be referencing victims as she and offenders as he. This is not to diminish or minimize victims that may be male. and also those crimes and cycles of intimate partner violence that may be based on an LGBTQ relationship. However, the majority of these offenses usually involve a male perpetrator and a female victim, so just for ease of reference, those will be the pronouns I'm using, but hopefully a lot of the information is equally applicable across the field. The other thing we want to do is we want to be focusing on offender and predatory behavior, and by predatory behavior, we want to start gaining an understanding that intimate partner sexual violence, sexual assault crimes, it's not something perpetrated, that this is something that's done with deliberation and with planning beforehand. We also want to talk about some best practices or an overview of conducting trauma-informed interviews of victims, not only because it's the most empathetic and nicest way to treat victims. We want to talk about why that can be best practices so we can learn more about the case and gain more evidence about the crime that's involved. And one of the things we want to specifically address in terms of commonly seen defenses is we want to talk a little bit about the consent defense, which is often and commonly utilized in intimate partner sexual assaults, but by no means is the only defense issue we're dealing with in cases of this nature. So the first concept we want to talk about and present to you when we're talking about intimate partner sexual assault, intimate partner sexual violence crimes, is the concept that when sexual violence crimes, intimate partner sexual violence crimes are occurring, they're most often going to be occurring in a context of an intimate partner relationship, and there's more often than not going to be an overlap in that relationship between sexual violence and physical violence crimes. This dynamic, this co-occurring of crimes, this overlap, it can often be overlooked because we're often, as investigators and prosecutors, we're only responding to specific episodes that seem to represent their own challenges. In other words, there's a report of physical violence or there's a disclosure of sexual violence made by an intimate partner, and a lot of times the investigative and prosecutorial concentration is just on that one response. However, intimate partner cases, whether it's sexual assault or whether it's physical violence, they aren't occurring episodically in the victim's life, but it's happening within the context of their whole life, what the perpetrator is offending on them and what they're suffering. So sexual and physical violence is something that can be co-occurring and connected by the threat of power and control that the offender is often going to be utilizing over the victim.
I think a lot of people, when they first do an investigation, especially the investigators, the victim will come in, they might say, look, I got punched in the eye or I got strangled, but they're really too embarrassed to say that they were sexually assaulted. And you do see it go hand in hand. I mean, it just overwhelmingly that when you have physical violence in an intimate partner relationship, you're going to have some sort of sexual violence to go along with that. And like you said, we do forget to ask that sometimes, and the victim will not say that it happened for either embarrassment or because you didn't ask it. So it's really important to ask those questions in them interviews.
Thanks, Tom. So the other thing that we want to talk about and gain an understanding of is try to get an appreciation of some of the data about the pervasiveness of this overlap and co-occurrence with intimate partner violence and intimate partner sexual assaults. And what we have here is a reference to a National Institute of Justice study that was done, and this information was last updated in June of 2017. And it certainly helps us understand the scope of the issue and problem and why a holistic approach to investigations and prosecutions might be better recommended. 2/3 of women who are physically assaulted by an intimate partner are also sexually assaulted. Of the 2/3 that were also sexually assaulted, 80% of those women were victims of repeated sexual assault by their intimate partner. So what the data shows and what we understand as these areas are researched and investigated is that an offender willing to perpetrate physical violence against their intimate partner isn't necessarily going to be reluctant to draw the line and not cross the threshold of also committing or not committing sexual assaults against them. There's an overlap, and like physical violence is often ongoing and not just episodic, so is the sexual violence and the sexual assaults that are occurring. So that's a little detail and some information about the pervasiveness of it. but also the impact of these crimes and why it's so important that we try to adopt a best practice approach and a big picture approach in the investigation and prosecution of these crimes. Because a danger assessment, this is a study found by Dr. Jacqueline Campbell out of Maryland from the NCDSV study, what that's discovered in terms of impact is that forced sex has often been found to be a lethality factor when conducting risk assessments of domestic violence victims. So in other words, just like strangulation can be an assessment factor, a factor of greater risk of lethality for our domestic violence, so can episodes of forced sex and intimate partner sexual assault. One thing, we're talking about intimate partner. Obviously, many times this intimate partner relationship is going to be involving some sort of context or happening within the marriage. The law is pretty common and generally understood today because there's been a lot of progress in this area, but that marital rape, it can be a serious form of violence that can have life-shattering effects for its victims. Almost every jurisdiction does not recognize a defense to marital rape. Marital rape has been illegal in every state in the District of Columbia since 1993, although it's not always and often prosecuted. It's infrequently prosecuted. Some of the reasons can be that as investigators and prosecutors, we don't know to look for it, and sometimes it's not something that the victims are comfortable or they're too ashamed to report. However, on the issue of marital rape laws, please be familiar and know your jurisdiction. I know we have a national audience today. Marriage is not going to be a defense to rape, and there's no right to rape because the offender is married to the victim. However, some jurisdictions permit some kind of marital defense unless there's some quantum of physical force accompanying the rape, either victim circumstances. In other words, there are some jurisdictions in the United States that only don't make the marital rape defense available if the victim's incapacitated or if there's some significant physical force. Intimate partner sexual violence, sexual assault cases have specific and unique challenges, as we've addressed and as we've talked a little bit about already, is that these cases are often going to be underreported. Tom was talking about it a little bit. Some of the reasons these can be underreported is the victim isn't comfortable talking about details of sexual contact when physical violence is reported. Other times there may be a victim who's reporting being a victim of intimate partner sexual assault, but is too ashamed or embarrassed or several dynamics to talk about the physical violence that may also be co-occurring. And as we're going to talk about, these cases, whether it's going to be an intimate partner sexual assault or intimate partner physical violence, they're often going to have similar kind of dynamics. And the kind of dynamics, it's going to be a dynamic that's grown over and evolved over a course of conduct where the offender, through subtle and nuanced progression, has used escalating forms of violence and power and control over the victim. The offenders in these cases are usually going to know their victims better than anyone else, and by the time investigators and prosecutors are on the scene, usually know more methods to exert control. And finally, even though marital rape is no longer recognized in any jurisdiction, victims may not recognize the sexual violence occurring within a marriage as being a crime, and it may also cause reluctance to report. Tom, do you want to add about any of the challenges you've experienced in law enforcement and working these cases over your long career?
Well, I can tell you that, victims not recognizing that it's an assault, the assault is a rape, is one of the big ones. I think that, a lot of people do still believe that, you can force sex in marriage. So when they come in and report, they know they're not supposed to be punched in the face, but they may not realize that they are actually forced to have sex and raped. And the other part is the embarrassment. This is a person that you really trusted, and this person not only now has physically abused you, they've sexually abused you. And how do you tell? I mean, how do you tell your relatives or your family even, let alone a stranger in the police department? So there's some of the challenges. I mean, the other challenges you have is that, if it's a marriage, the whole home is going to be totally destroyed. The kids, your economic background. You got all these challenges just to have someone come in and make the report. So that makes these really, really difficult.
Thank you, Tom. What I next want to talk about is the power and control wheel. This is probably familiar to folks who've done a lot of work or a lot of study into the areas of intimate partner physical violence. But the concepts and principles equally apply to an understanding of intimate partner sexual violence well. And essentially what's posited here is that power and control, understanding the offender's use of trying to have power over the victim and control the victim, is critical to understanding how it's an intimate partner abuse is perpetrated against the victim. And this wheel shows a lot of the methods in dynamics that can be co-occurring at the same time for this offender to exert this kind of control over victim. And you look at the specifics and you read this list, and certainly there are things that always ring bells in cases that I've worked with. I've certainly looked at offenders that use the children as a tool. Often if a case is pending and there's going to be some sort of contact allowed with the children, they're often used by many offenders as a way to control the victim, as a way to get access to the victim. Certainly a lot of offenders that I've encountered and had to prosecute in my time, they isolate the victim and so that they're financially dependent on the offender for income for the family and for support of the children. Other times the offender's expecting the victim to produce all the income for the family while they control that. Then there can be intimidation. There can be graduated and progressive and escalating emotional abuse. I shouldn't use the word progressive, but escalating emotional abuse, as well as isolating the victims from any sort of support networks, whether it's a separate set of friends or family or things of that nature. But Tom, I know you've worked with a lot of these concepts. That are being talked about in power and control. Can you talk about some of your perspective?
Well, I can tell you that looking at this wheel, and we call it power and control, I think we could change it to say that these are the weapons used by the perpetrator of sexual assault. Every one of these things is used as a weapon. I mean, sometimes we look at the weapons to be a gun, the fist, a knife, but every one of these is a good weapon. And then when you start adding them up, you take total control over the person. I mean, it's almost, if you look at every one of these, it's very similar to someone who's been brainwashed or tortured. Isolation, using emotional abuse, using intimidation, threats, the economic abuse. You'll be out on the street. I've had it one time where I remember a woman coming in and she told me it was like the 10th time that she was sexually assaulted. And, you ask, like, well, why didn't you report it? And she said, I'd rather, at first it was okay to be sexually assaulted rather than live in a box. But then she just realized it was too much to deal with. So, I mean, when you hear someone tell you that, you realize what some of these things can do, like the economic abuse. They knew that if you reported it, it should be on the street. Or the emotional abuse. You're not worth anything. Who's going to believe you? All these things are weapons that are used by the perpetrator, and I think that we overlooked that a weapon doesn't have to be actually a weapon in your hand. Doesn't have to be a gun. Doesn't have to be a knife. That every one of these things on our wheel is actually a weapon to be used and then continue to be used to take control over the person.
And that's wonderfully put, Tom. We talked about one of the objectives of this webinar is to understand the predatory nature of offenders. And this is an example or illustration of that, is that the offenders, when they're perpetrating sexual assault against their partner, against an intimate partner, it's not a spontaneous kind of crime, but it's a component or a part of an overall cycle of violence. And some of those parts viewed in an isolated manner might not be criminal in of itself, such as emotional abuse. But learning about that, understanding about that big picture is not only going to help us understand victim responses and victim behavior to intimate partner sexual assault, but getting that evidence and seeking that evidence is going to make the prosecution a bigger picture and give the jury a bigger picture of what's being perpetrated in these crimes by the offender over a cycle, not just a snapshot of when we had an opportunity to respond to a report.
And it's always great to know why, what was the victim feeling? And when you look at that wheel in your interviews, you're able to find out, well, he intimidated me by, threatening me. He told me I'd be out on the street. Who would believe me? And now you have an understanding of why the victim may not have reported it on the first instance, or she's reluctant to even report that part of it. Just the part that she had no choice now because she's showing physical injuries. It's really important to ask about all these issues on our wheel, to establish those weapons and actually show how was that person feeling when they were living there and going through this experience.
Force or threat of force. Prosecuting sexual violence cases, sexual assaults, we're trained to understand and we're looking for the evidence of force that coerced the sexual intercourse, that coerced the sexual contact. And with intimate partner sexual violence cases, it goes back to, I think, a theme we're going to be repeating a lot and that we've already talked about a lot. It's trying to get a bigger episode, a bigger picture than just what presented in a specific criminal instance. Certainly, if an instance of intimate partner sexual violence or sexual assault, if there's force used by the offender against their victim, if there's threats, that's going to be evidence. But we can get a better understanding of force or even implicit force that offenders use to coerce victims by trying to get a bigger picture and a context in the history of the relationship. So proving force or threat of force in intimate partner sexual violence cases, it's going to be requiring a broad approach to showing some kind of forcible compulsion. Part of trying to understand the victim's fear and offender's coercion of the victim is also going to be improved by understanding the physical violence that's been employed and probably has been employed in the history of the relationship. That kind of history of violence, or what we're sometimes going to be calling that kind of context to the specific crime we're investigating, is going to be probative of force that's going to be utilized in a specific incident of intimate partner sexual violence. So, for example, I mean, most of us know if we have a rape case, if there's a beating that immediately precedes the rape, we know that's proof of force that's used in the rape, and we can understand that and we can look at it intuitively because it's close in time. But an intimate partner dynamic between the offender and the victim, that's going to have a bigger temporal timeline than just what immediately happened prior to the sexual assault. So if there's a history of physical violence and the victim has knowledge and she's aware of that physical violence, the victim's ability to consent without fear of physical force to sexual activity is diminished because the victim knows this history, the victim realizes this history, and the victim understands that history. So trying to understand and investigate and gain evidence of and learn about with the victim and from the victim about past abuse and other acts, that equals force and can help us understand and make the argument to fact finders and juries that the force used in the specific case does not need to be overt. So even though we might be responding to these cases based on an immediate report, to be successful for best practices, we really need to take as big a picture as possible, similarly to how we do in homicides. We don't just look at what happened when the murder occurred, but we try to find out everything that happened leading up to the murder. And in the case of intimate partner relationships, that means trying to unpack what happened throughout the relationship. Tom, did you want to add anything to that?
Yeah, the part there where you have, like, the current and former victims, when you go back and look at the perpetrator, you're going to definitely find other victims. May not have been a sexual assault victim, but definitely physical violence victim. And the other important thing, too, is a lot of times what you'll find is our victims have been previously abused by other males in the past, especially physical violence. And, when you talked before that these people are actually predators, sometimes they see, this vulnerable victim. They see someone who may have been abused in the past and use that against them, similar to like grooming, in child abuse cases sometimes. They look for someone that they know that, they believe they can get away with this until the victim becomes strong enough to report it.
So as we initiate these investigations and prosecutions, one thing we have to be really conscious of and sensitive and alert to is the idea of victim safety. And not only because it's the right thing for our victim, but successful investigations and prosecutions are going to need to be proactively or preemptively anticipating victim safety issues and the risk of intimidation to the victim. Now, there's going to be some circumstances where we're going to be reactive to victim intimidation when it's occurred, but if we can try to be preemptive as possible, that's going to be a lot easier than being reactive to it. Essentially, when we're working with either intimate partner violence cases or intimate partner sexual assault cases, there needs to be sort of an intuitive understanding that just if we're working with a witness for a gang investigation or gang prosecution, witness intimidation should be ever present. Same thing with these intimate partner type prosecutions, is that witness intimidation is going to be a constant issue. And so we want to, one, be able to assess the risk based on risk to the victim and indicators of lethality, but also be aware and start talking to our victims about what intimidation can look like and the shapes it takes. It could be apologies from the defendant, which are nothing more than admissions of guilt. It could be statements about the offender about how much prosecutions or investigations are going to cost in terms of the relationship and that there won't be financial resources or money for the family. Or it could just be either old-fashioned explicit intimidation, making the victim feel so scared that the risk that's going with the prosecution isn't something that's worth it. It's usually the only kind of intimidation we usually find out about is going to be the unsuccessful intimidation. So we want to be educating and talking to our victims about it, and we want to be following up when it occurs and when we see it. Do you want to talk a little bit about your experiences with witness intimidation and talking to victims about it and some of the shapes you've seen it take, Tom?
Yeah, I mean, a lot of times, our victims already come in feeling bad, because they have feelings for the person. They don't really want to see them go to jail. And then they start, they do a lot of times talk to the perpetrator. And you'll find out that they have all those things that you talked about, financial, how much it's going to cost. We're all going to be on the street. I'm going to lose my job. What about our kids? All those forms of intimidation, especially the family dynamics, is really what's going to have, our victims decide not to prosecute. And it's hard to stay on top of it, but they're the kind of threats that we've had. Of course, you get the ones where you will have violence later, but I think it's the most of the ones that you're going to have are the type where you're talking about the finances and how the family and how about our kids. What are they going to think if their dad's in jail? I'll never do this again. They all play on the emotions because, as you said in the earlier slide, they know their victims better than anyone else. They know what buttons to push, and that's why a lot of times these cases fall through.
And I think that's a good point. And just to briefly add on to that, the things that our offenders were doing to manipulate, control, and exert power over the victims prior to prosecutor or police involvement, the offenders aren't going to give that up just because an investigation has started, just because charges have been filed and a prosecution is initiated. They're going to be continuing to try to exert that kind of control over a victim, and the foundation of which has been built up by an offender long before we ever got involved with the case, and that the victim has been subjected to and exposed to. So what we wanted to talk about is establish is just the co-occurring of the intimate partner sexual assaults and intimate partner physical violence, and some of the ways in which the crimes are perpetrated. But when we get these cases, we want to talk about how to conduct an offender-focused investigation and identify and interpreting the evidence that can hold the offender accountable for the crimes they've perpetrated against the victim. And part of what, to me, a focus on the offender means, and what I understand that to mean, is a recognition that it's building a case by focusing on what the defendant did. How did our offender set up their crime? How did they plan their crime? What, if anything, did the offender do to cover up the crime? The offender-focused investigation and focusing on the offender, it's first looking at how the offender completed this crime. It's not being reactive to victim behaviors that may be a challenge or making apologies to the victim, but those behaviors of the victim that are a challenge in the prosecution, it's an understanding and trying to connect it to something that the offender set up, something the offender laid the foundation for, so that we can show that proof for the sexual assault, for the force that was utilized in the sexual assault, and how the offender completed their crime and planned the crime and had the opportunity for their crime as well. what that means is this offender-focused investigation, probably the central component, of course, is going to be a victim interview and a trauma-informed interview of the victim, which we're going to talk about in just a moment. But then building off the evidence we learn in this in a trauma-informed victim interview, it's just like a homicide case or a murder case. It's looking for as much evidence as we can to corroborate this victim's disclosure and this victim's experience in this cycle of violence and sexual assaults to prove our charges or to prove our case of intimate partner sexual violence. And it's going to be medical evidence and trying to find doctors and medical treatment, medical records that are both current and historical, looking for experts, whether it's going to be forensic evidence experts or victims to help explain some victim behaviors that may be challenging or counterintuitive in understanding, trying to obtain an offender statement, even if it's self-serving, looking for other witnesses, even if there's usually never any eyewitness to this case, finding as many witnesses who are familiar with just the history of the relationship and the cycle of relationships so they can offer evidence. And of course, digital evidence these days, such as phones and social media and things of that nature, hopefully anything that can be attributable to the offender, but when we need the victim's electronic devices and communications, taking steps to try to protect the privacy that the victim deserves as much as possible. And Tom, I know I talked a lot about the offender-focused investigation, and you're the one with the most expertise and background. Can you talk a bit about this?
Yeah, I'll talk a little bit about that, but when you look at this slide, I think what a lot of people don't do and don't realize is that this is probably your hardest investigation. This is much harder than a homicide investigation, but you need to do everything you do in a homicide investigation. Getting forensic evidence, looking for secondary witnesses, any kind of evidence you can get. You need to do that in these types of investigations. They're time-consuming, they're more intensive, but they have to be treated as if it was a homicide or if someone was in a home and, someone broke in and raped a lady during the middle of the night. These are just as serious as every one of those crimes and need to be treated as such, and the investigation has to be done like that. I can tell you as part of the offender-focused investigations in Philadelphia years ago, we did not do that, and we learned some of the things that we do is, a victim's already going to come in, especially in these kind of cases, somewhat blaming themselves, like, it's my fault in some way, and the focus of our investigation is really not ask questions that put more blame on the victim. We learn to get away from the why questions. Instead of that, asking, what do you remember? Or tell me what happened next. Because automatically, once you ask those questions, you're changing it from offender focus, you're blaming the victim. They're blaming questions. And a lot of times we do that instead of focusing on, like you said earlier, what did he do? How did he set this up? What did he do afterwards? What kind of grooming did he do to make sure that she's not going to report this? And then what did he do afterwards to make sure he didn't report this? And not only that, then they add in the community. Other people what are you going to do? I mean, if you report him, he's going to go to jail. What's it going to happen to you? So there's a lot of influences in these types of cases, and all that becomes part of what the offender did when he starts to get these other people involved and what he did afterwards. But we have to be more focused on what he does and not what the victim did. We really have to make the victim comfortable enough to be able to tell us exactly what she felt during the sexual assault and how intimidated she was prior to and afterwards.
Thank you, Tom. So I want to talk a little bit, because we have talked about it being such an important component, is this interview of the victim. And we want to talk a little bit about trauma-informed interviews of the victim and the importance of that. And what we're meaning by trauma-informed victim, Tom has really eloquently already addressed a little bit about it. But when we meet with the victim, understanding that what happened in this case, even if she may be thinking that this isn't something that was her fault, and we don't want to amplify any sort of feelings of self-blame or doubt that she's having in the case, but recognizing that our victim and that the information she has is going to be a great and probably the best resource we have to follow up on other evidence, get details for other evidence to try and hold this offender accountable. And so we want to be as empathetic as we can and as respectful of the victim's trauma and when we're meeting with her, because it's going to be a better tool to help learn information from the victim. The safer and more comfortable we can feel the victim, the more recognition we gave of the pain that has brought her to meet with us, the better it's going to be for us not only to treat her right as a human being, but also to learn more evidence in our case and information about our case. But there's a couple of approaches that we suggest that with our trauma-informed interviews, that when we meet with the victim, that we have a witness, that we're not meeting with the victim alone, especially if you're the prosecutor, of course, because if you're meeting with the victim alone, you don't want to make yourself as a witness. However, in having a witness to the case, we want to be sensitive. We don't want to make the environment intimidating or make the victim feel less safe or she's being judged. Whatever the choices are of the victims, we don't want to judge or disparage. We don't want to be asking, as Tom was saying, why did you do that? But we more want to be approaching and getting information about the victim as, what are you able to tell us? What are you able to tell us about when you met the offender? What are you able to tell us about when in the relationship maybe you didn't feel safe? What are you able to tell us about what happened about the sexual assault? We don't want to coach the victim, certainly by asking directed or leading questions, but after we've built this level of rapport with the victim and there's a trust there, if what's called us into an investigation with the victim or allowed us to meet the victim has been responding to an episode of physical violence, if we have a rapport there, it might be okay and it might be appropriate to inquire whether there's ever been sexual violence, whether there's ever been sexual contact that she didn't want or felt forced to commit to. And then just follow the truth where it goes. Because that's our first goal in this case, is it's not to get to an end result other than learning the truth. And the wonderful thing about being prosecutors, about being police, is we're paid in our jobs to do the right thing for the right reasons, and that's finding the truth. And oftentimes when we build the truth and we diligently seek it and pursue it, it's going to meet the second objective we have, which is building our case.
Hey, John,
so
real quick, talked about disparaging and making judgments. That could be a simple sigh when the victim's telling you something, or a look in your eye, and the victim's going to pick that up and believe that you don't believe them, and you're automatically making a judgment. It doesn't necessarily have to be the questions. It's actually the way you present yourself. And I've seen it where just a little sigh, instead someone tells you, here's what happened, and you hear, okay, what happened next? I mean, just that little sound in your voice is picked up by the victim. And you can lose your victim and traumatize her more than she's already been.
So, and this is, I think, really a good summary, and there could be an entire webinar and presentation on trauma-informed interview. We're trying to give you a little bit of a snapshot or digest of it. But a lot of what trauma-informed practices distill down to is learning to listen to the victim, learning to ask the open-ended questions and then follow up with questions where we need to get detail or see if there's more detail, not trying to force or pry, not trying to interrogate a victim, but learning to listen to the victims and just asking them for descriptions about themselves and the defendant and the history of the relationship and just the background, because we're trying to learn the overall historical picture, not just the assault. But of course we want to learn as much as we can about what happened either right before, during, and after of whatever kind of sexual assault we're responding to or that initiated our investigation. But we have to understand and appreciate, and there can be a tendency to expect or want to hear what happened in some chronological narrative. But the reality of trauma, of victims in trauma, of people in trauma, is that it may only be coming in pieces, and it may not come with a compact and consistent temporal or time narrative or chronological narrative or anything of that nature. Did you want to add to that one, Tom?
Yeah, I mean, when you ask them, when you're talking about what happened during the assault, it's really important in these cases to ask the victim what they were feeling during the assault, and even sometimes, what did the defendant look like when this assault was happening, And I remember one time asking what the defendant looked like, and she says, it wasn't him. He had a blank stare in his eye like it wasn't him. And I just thought that, I just wanted to be alive for my kids. I mean, that's powerful evidence that you don't get if you don't ask that question, because they're not going to tell you those things unless you ask the question. So ask them what happened during is really, really important, especially how they felt and what they were feeling during the time of the assault.
So asking them what they felt, I want to build off of that. I think that's an important part of trauma-informed interviewing too, is that when we're talking to the victims, not just asking a what happened, but it's soliciting not just what you happened or what you saw, but trying to solicit other kinds of sensory details. If they remember hearing anything, smelling anything, any physical sensations, getting those kinds of details that may have really made an impact in their memory, and hopefully might provide us details which corroborates a disclosure, or that can be followed up on with other witnesses or other evidence or the physical scene or processing of the physical scene. But also, like, as Tom was talking about, that can be really powerful, asking victims how they felt, what were you thinking, and offering that, and that's where you get really the most vivid details about the kind of fear that they were experiencing, that helps bring home the impact of the suffering of this crime on the victim, and that can be communicated to juries.
And the slide here where it says, be aware of the effects of trauma on memory. We're learning a lot about that now, and you got to remember that they're not going to be able to tell you everything. They may not remember some things, and they may come back with it later. That doesn't mean they're lying. I mean, the people always believe that you got to have your story straight, otherwise you're lying. Well, we're learning now that that's not true in trauma, especially sexual assault trauma, and you have to expect those memory lapses or remembering of memory things that happened. And that's important, even to let the victim know that, you may not remember everything, but if you do remember something, please let me know. I think that's really an important part of it, because, the way people have been taught over the years is if your story doesn't match, you're not telling the truth, or it's not consistent. And in these cases, as we're learning now in trauma-informed interviews, that does have an effect on the memory. Sometimes they may not remember everything. Sometimes they will. Sometimes it might be the day of trial. They remember something that they didn't remember before, and that's important to know.
Following up on that too, about the effect of trauma on memory, one of the things we should be prepared to understand is that victims are frequently going to be disclosing in layers. We may not learn everything the victim has to offer us in one meeting. Certainly a first response meeting where the stress is most acute, that the trauma is most acute from whatever crime happened, we might be able to learn about jurisdiction, who the offender is, and a broad outline of the crime, but that's not going to be the best opportunity to follow up and try to learn as many details. Victims are frequently going to be disclosing in layers, and it might take, not after we've had one meeting where we've maybe just established some rapport, having subsequent meetings and interviews with the victim that we can learn about more crime, and the victim's comfort level rises, and we learn more about what happened. So often the victims are going to be disclosing in layers, especially when we're dealing with such wide impacting, wide scoping crime related to intimate partner relationships. Because basically these kinds of crimes build up from when the relationship started to whatever brought us in to respond, and then are ongoing throughout the prosecution. For a victim to disclose the whole history or that whole story takes time, and there's a lot of information that's compacted in there, and it's going to take us a while and time to be meeting with the victim to learn about that. So the offender interview, we would recommend that that an offender interview should at least be attempted. More often than not, a lot of offenders are going to be willing to talk, and if nothing else, give a self-serving statement, which can be beneficial for a prosecution because at least the offender is locked into a version of events. Sometimes an offender may even give a confession or something inculpatory or admission, something that can be shown to be inconsistent with physical evidence, forensic evidence, or something of that nature. but we never have those opportunities if at least interviews aren't attempted of the offender. But Tom, do you want to talk about some strategies you employ or suggest in the offender interview?
Yeah, I mean, in these type cases, the offender usually will want to tell you something because they believe they didn't do anything wrong. So they're going to be able to tell you something. Some of the important things I think you need to talk about is kind of like, when did she give consent? Did she ever say okay? What made you think she gave consent? They're the important questions, I think. Along with, depending on the case, was there any alcohol involved? When did the time happen? Have you done this before? Has she been that way with you before? Because now you may be able to get some other incidents where you did the same exact thing to her, and she's not telling you because she's still embarrassed that she may have, allowed this to happen a couple times before she reported it. But I think the offender is going to tell you, he's going to talk to you because he doesn't really think he did anything wrong. You want to get the details of what happened. When did she consent? How do you know she consented? What did she actually do during the course of your contact? And then, what happened afterwards? Did she seem upset? Was anything any differently? Was she acting any different? All those things are important. You're going to establish that something did happen. And it's like any other case. It's a credibility case because you're going to be thinking of, when you go to try this, the evidence isn't going to establish anything for you unless there's injuries, but you still have to get all the evidence to show that something happened that day. But the statement from the offender is really, really important.
Thank you, Tom. Well, the other thing we talked about, and you may remember we talked about it earlier, is we talked about history of force being used in the intimate partner relationship being critical in helping to show or helping to prove that the force that was used in the rape or the sexual assault itself. And we want to talk a little bit about places where you can find it. And this is sort of some possible resources of trying to find or opportunities or resources that may give you evidence of the defendant's use of force or employment of force either with this victim or with other victims to complete the kind of crimes that he perpetrated against the victim we're working with in our case. But probably, let me just talk about too, with the victim interview, talking about and trying to explore with the victim not just the sexual assault itself, but the history of physical violence within the relationship itself, and using that cycle, that history, in that context to help show the threat of force or the implicitness that was backed up with any use of force in the specific sexual assault that we've charged or that we're prosecuting or investigating. But usually our victims is going to be the first stop to look for any or to find out about any history of violence that was occurring. But of course, this might not be the first time that there was police contact with the offender, maybe not the first time there was police contact with this offender for crimes perpetrated against this specific victim. So certainly looking through the defendant's criminal history, exploring that might reveal other crimes. Using CODIS hits, if there's an opportunity to get the DNA, to do a DNA analysis of the defendant, maybe if our victim has had a rape kit done and there's a kit that's sent off to the lab, even if the defendant's asserting that the contact was consensual, nevertheless, making sure the lab analyzes and does a DNA comparison to see if when the defendant's DNA profile is loaded into CODIS, if it matches to any unknown profiles or other crimes, maybe with other victims who the defendant has perpetrated in a similar fashion against. Whatever your jurisdiction calls them, and from Pennsylvania, we call them protection from abuse orders, restraining orders, but civil protection orders and applications for it can reveal a history of violence that maybe law enforcement never was involved in. Prior police reports can give information and perhaps other witnesses the historical incidents of violence that might inform or be probative of the use of force that's used in the current sexual assault, prior partners of the offender that he's offended against or perpetrated against similarly. And of course, social media, something data-rich but labor-intensive in my experience is if the defendant's in custody while the case is pending, reviewing and listening to jail calls may reveal or show admissions of force or witness intimidation. And the other factor is too, and a lot of times in these cases, a common tactic used by the defense is obviously finding some characters to present good reputation of character or something like that. And one of the things we don't always use is we don't always have ready and rebuttal people who can testify but otherwise would be totally willing to talk about maybe the bad reputation that the defendant has. And having these rebuttal witnesses handy in the event that the defendant tries to use reputation evidence can make our trial efforts much easier and much more productive. Do you want to talk about a little bit about investigating? Oh,
yeah,
sorry,
I mean,
Tom.
the part there about the police reports, I think some of the things that we don't do, especially if you have a small jurisdiction, you should check the other jurisdictions surrounding you to see if anything he's ever been the subject of an investigation there, because it may not be on the police records if he's not been arrested, but it will be. They will have a record that an investigation was conducted, and a lot of times in small jurisdictions, you don't have access to getting anything from the surrounding area, or check where he's lived at, or even check where he went to school at. There may have been an incident, he may have been into college, and it was an incident in college. But all these things need to be done. Sometimes the victim interview, John, too, is, this may have been the first time there was physical violence that occurred during the sexual assault. That's why the intimidation and the implied violence is really important to know, too, because that's just as intimidating as physical violence. We need to know that, too, before we go forward.
Thanks, Tom. The other point about these cases, of course, and Tom has already referenced it, these cases require time. It requires time for investigation. It requires a lot of time for prosecution. They are as hard or harder than homicide cases, and we have to have that expectation going in because, again, we are trying to offer juries not just a snapshot, but an overall picture of what occurred in the history of this intimate partner relationship. But in providing the jury with context, the other thing we want to talk about are some methods that can be utilized to get this history or context, this history of violence or context of force in a trial. Probably the best ways to make sure that this kind of history is admissible is in broad-based charging decisions. Certainly if there's prior crimes that are within the statute of limitations that were never prosecuted, maybe charging that along with the current charge of sexual assault or rape that's being prosecuted or investigated. The other method, though, is if there's a course of history, a course of conduct by the offender that demonstrates efforts to put this particular victim in fear of emotional distress or put her in fear of bodily injury, look at a stalking charge as a way to try and, as a evidence that is a crime that has an element which allows for a broad door for all this evidence to come in so that juries can get the whole picture that's involved. Certainly there's other exceptions such as re gesti. There might be consciousness of guilt methods to bring in these other sort of contextual acts by an offender, especially if there's witness intimidation. But the other method to look at too is for proper purposes under Rule of Evidence 404B or the equivalent under your local jurisdiction. Because we're not bringing in this history of violence or this overall context of violence just to show the defendant's a bad character, but we want to do it so we can show and prove to the fact finder, to our jury, the defendant's motive in committing the sexual assault against our victim, the intention as proof of intent so we can meet our burden of under a reasonable doubt, or especially if there's a consent defense offered to show that there is a lack of accident or mistake by the offender. So, and essentially, this historical evidence, why it's so charged, why it's so important, because if we just present evidence of the incident that's charged, we're really not giving our jury a whole picture. And what we really want to try to do, I'm glad the animation worked, is by looking for all this historical evidence, this contextual evidence, we're giving our jury a complete picture of the crime and making it easier for our victim to get justice and for our offender to be held accountable. These efforts too, and I'm going to ask Tom to add in on this one, we want to try to pursue all kinds of sexual violence and sexual assault cases as much as we can with multidiscipline cooperation and collaboration between our partners. And certainly the common one, and one that's going to be vital, is prosecution and law enforcement working together. I know I'd always ask my law enforcement officers, hey, contact me the earliest opportunity. It's okay, you can take my life over when you get a report, because I know if there's a trial, I'm probably going to be looking to take your life over in the weeks leading up to trial, so it's fair you do the same thing to me. but we want to be working hopefully in some sort of community coordinated response context or in a SART context with advocacy providers or other kinds of service providers as well as medical providers. And Tom, I know when you were practicing, Philadelphia had a very active and organized SART team. Can you talk about some of the benefits that you learned from that?
Well, I can tell you that, I mean, working with the SART team, we learned a lot. We learned a lot about evidence. We learned a lot about what evidence to take, how long it lasts, and we were able to change the way we collected our evidence. I mean, they actually changed our rape kits to make them more beneficial, both the prosecution and the victim. Not taking evidence that wasn't needed. It was great to have everyone working together because they helped us learn the proper way to do an investigation, the proper way to ask questions, the proper way to treat the victim, and how to have a better case. And then as far as prosecution, we really had a good relationship with the district attorney's office. They had people, their chief, as you were, was on call 24 hours a day and answered any one of our questions. I think a lot of times with investigators, especially in smaller jurisdictions, the investigator does everything themselves. If they feel that case ain't going to go to court, they don't even contact the district attorney. I think the district attorney should be involved in every case. And the district attorney should let the investigators know, here's the kind of case we're going to take, and if you work hard and give it to us, we're going to prosecute these cases. And that when you have a case that you're not sure of, prosecutors are able to say, look, go find me this amount of evidence. Here's what I need to prosecute. If you have that, we'll prosecute. Everybody works hand in hand. A lot of times the medical part of it, the sane nurses are able to really comfort our victim even before we speak to them. And they're very important in the court case also. But I think a lot of times it's overlooked how much they actually comfort and help us in the next step of doing an interview with the victim. So, the service providers, everyone involved, we're all part of this team, along with the victim. And everybody's got to be working together to support the victim in this case.
So great statements about the multidiscipline collaboration with one another. We already talked a little bit about witness intimidation. We should prepare our victim for this, help our victim understand that the offender, if they give apologies, that's a confession, preserving any evidence of contact from the offender, and also follow up. Every time we're meeting with the victim throughout the investigation and prosecution, being a little bit proactive with them and asking, hey, has the offender tried to contact you? It may not be information that our victim is spontaneously volunteering. We should always be checking in and touching base with our victim to learn if that's ongoing or if that's happening. So when these cases, and the investigation is never done, so I don't want to draw a line between, well, the investigation is done, charging happens, and preparing for trial. Trial prep is always happening from the minute the crime is reported. Investigation is always happening up until a jury returns a verdict of guilty or a defendant pleads guilty. So I certainly don't want to get into a situation where we're compartmentalizing with that. But one of the things we want to do in terms of pretrial litigation is, as much as we can, we want to build up our record with motions. If we have these evidence of other crimes coming in through 404B or through some other method, most jurisdictions are going to require some kind of notice to the defense, and that notice can sometimes be broadly construed. But what we recommend is the better practice is to try and litigate the admissibility of 404B evidence prior to court, not just give an oral notice, but actually ask the court through pretrial motions in limine to determine admissibility. This can be especially helpful if your case has if your jurisdiction has good rules on interlocutory appeals, and that's an appropriate option for your case if it's not admitted, pursuing something along those lines. Making pretrial motions to determine the scope of any expert testimony you want to present. Also, making sure that we're anticipating unfair or inappropriate character evidence against our victim or attacks against our victim. Finally, pretrial motions to make sure that's precluded or excluded, or at least put the defense or our defense attorney friends in a position where they have to defend why that's relevant, so then they can be locked into the scope of its reasoning. other things in every case, and this is standard advice, I don't think just sexual violence case, offer the court proposed jury instructions and charge written out that frames the law as favorably and fairly for our case as possible, and will make the court's job easier, especially for asking for any special points in the law, but preparing that for the court and doing it in a professional and complete way. And if there's any statements whose admissibility we think we might be challenging, filing pretrial motions asking the court to determine that admissibility in the context of what the anticipated evidence will be. With juror perceptions, too, we want to understand that just like sometimes without training and understanding the best practices, we may have some preconceived notions. Jurors may also have those kinds of preconceived notions. So we want to try to challenge and design voir dire questions that can be used to educate our jury, as well as elicit any views that suggest that they're not going to be able to be open-minded and fair as to what the evidence proves or not proves in this case, in our particular case. If you go to the Equitas website, we have several resource articles that detail a lot about jury strategies for these cases, and I reference our audience to that. One thing I wanted to address, and that was part of our objectives, and I apologize for moving so quickly at this case, is overcoming the consent defense, or explaining consensual encounters prior to or following the assault. One of the reasons we can do is that there's the victim behaviors that are a challenge. Why did she perhaps stay in the relationship? Why wasn't it reported earlier? Things like that. One of the things we might want to pursue is expert testimony, a victim behavior expert, someone who has specialized knowledge about working with survivors of sexual assault and sexual violence, and as well as domestic violence victims, and can talk about how, with experience and study on the subject, the dynamics of sexual violence and physical violence can impact disclosure and victim responses to sexual violence. And sometimes this is information, these victim responses that might be challenged by the defense or of concern to potential jurors. Sometimes it's something our victim can explain under direct examination. One point of law I want to make is when the defense is arguing a consent defense, a lot of times there might be legal limitations of that and something we might want to incorporate into proposed points of charge. I referenced Model Penal Code 2.11c here, and that recognizes that assent does not constitute consent if induced by force, duress, or deception. So certainly if we have a history of force or duress, we want to make sure our jury is instructed on that law, that if they find evidence of that, then the consent defense cannot be supported and isn't appropriate, and then utilize that point of law in closing arguments. And so sort of wrapping up here and getting towards the tail end before we close, with trial strategy, we just want to make sure we recreate the reality of the crime and relying on efforts by our investigators trying to show as broad a picture of the history of violence and coercion that preceded the sexual assault, focus on the offender and the betrayal and breach of trust that they perpetrated, make sure that we, as best we're able, to show the entire context of the relationship to our jury, not the specific episode that prompted police response or police investigation, and maintaining the focus on the offender and how the offender caused repeated trauma to the victim. So before I do a wrap-up, Tom, is there anything you want to add?
No, I mean, just real quick, I want to go back to where you talked about keeping in touch with the victim. I think that even before you're scheduling the interview, you should be in touch with the victim. One of the biggest complaints we had over the years is that they felt forgotten in between the time they arrest and, the several months towards trial, because usually we don't get to interview them until about, a couple weeks before the trial. That's important, that they don't feel that nobody cares about them anymore. That's one thing. And the other thing is the investigation really should be done. A completely good investigation should paint a perfect picture about what happened in the eyes, not in the eyes of the perpetrator. That's about all I can add to that part of it.
And Tom, and look, not just because of the time, but just with those words, I think that's a great way to close. Folks, I want to thank everyone for your attendance at this and for participating in this webinar. It's really an important subject. It's a good way to wrap up this month. I thank you for your time, and it's going to be, the information here will be archived, so if there's content we went over a little bit more lightly, it can be accessed later. But thank you so much for attending today's webinar.
Absolutely. Thank you again, John and Tom, for your insights today, and thanks for everyone on the call for your dedication to increasing victim safety and offender accountability in your communities around the country. John covered the consent defense a little bit at the end of this presentation, but just wanted to let you know that Equitas has a 90-minute webinar recording on overcoming the consent defense. So if you are interested in this topic, I invite you to go to our website and our trainings tab and webinar recording page, and you'll find that 90-minute webinar. So on behalf of Equitas, thank you again for coming, and we'll see you again at another webinar soon.